All right, this information then is patently illegal and unlawful, and in this kit you're going to have a one-sheet piece of paper that'll describe what Blackstone had to say about informations and how the king used to use them to oppress the citizenry and to intimidate them. And they're doing exactly the same thing today with informations that they were doing in the 1770s that so incensed our forefathers. I don't happen to have that right in front of the camera at this moment in time, but it'll be included in this kit. And there's a powerful argument. Just pick it up and read it to him. Now you'll notice that I read a lot of these legal quotations, and I'd like at this time to pause for a moment here and tell you that we're in the process of putting together hundreds of these legal quotations that come from literally hundreds of different cases, from police powers and counsel and search and seizure and all sorts of subject matter, IRS, etc. And we're going to make those available, and probably in the next 30 or 60 days we'll probably have another book about this size that'll have more legal quotations, which are just absolute dynamite in the courtroom. Boy, I love to sit in the courtroom, and I've read this book over and over, and I pretty much can put my finger right on one of these quotations when I need it. And somebody gets to talking about an issue, and boy, I'll just come up with the right line right from the Supreme Court of the United States. All right, now, on this last issue, there's a thing called a citation. Probably all of you from time to time have gotten a ticket. Now, a ticket in the state of Idaho is a legal citation or a legal complaint. But it's legal to the persons that it's directed to, and that's when the policeman catches you speeding or doing some little infraction like that. What you're doing is you have a curbside court, and we call those curbstone courts with executive police judges. You're actually in court. The policeman, he simply saw you and he said, okay, you're speeding. Now, if you want to appeal this, you can take it to the traffic court and you can plead to it and do something with it. All right? If you're a licensed driver or licensed in any capacity, whether it's for dealing in guns or dealing in alcohol or a bar or whatever it may be, you're obligated then, the jurisdiction is conferred by the statute and by your driver's license or your business license or whatever it is that you have that compels you into that regulated enterprise. Anytime you're in a regulated enterprise, that regulated enterprise is governed by some form of contract. When you're governed by a form of a contract, the issue is no longer rights. It isn't under the Constitution. It's simply a matter to be adjudicated and determined by the administrative law court. Now, I don't know what they look like in your particular town, but I'm going to hold one up here. This is an Idaho uniform citation, and as you can see there, it says Boise Police Department, and it's got a number up in the corner, 17927. When you begin this type of procedure in your own county, you're going to run into some real static, because the lower court judges, when you come in, are going to get the impression that you're some kind of a wild-eyed fanatic or kook. So always be respectful to the judges, and don't come unglued and go in there with a belligerent, nasty, surly point of view or tone of voice. That's really counterproductive in the long run, and I've done that to 2 or 3 judges in times past, and I can tell you from experience that there's no real benefit when you go in there and create enemies. As a matter of fact, it's more productive to go in and let the judge jump up and down, rant and rave, paw the ground, bite the bushes, and get all upset, froth the mouth, and do whatever it is judges do when they have a pro se come into the courtroom and demand his rights at law instead of his punishment under equity. But when it does occur, as they begin to read these briefs and motions as we go through them, and as they see them, and as they become exposed to them, pretty soon you're no longer this wild-eyed kook coming in here. You're a serious, sincere citizen who's demanding redress of grievance, and he's demanding his day in court. Then your respectability begins to pick up. And you'll go through a couple of jury trials, and you'll lose those jury trials, and you know it's a little traumatic when the jury comes back and they say, "We find the defendant guilty as charged on all counts." Well, the thing that bothers me the most there is that here's your peers, or here's this peer pressure, and they've rejected you, and so here's this feeling of rejection. They do err not understanding the law, so all we're going to do is to appeal this issue and take it into the district court, and then on up to our state Supreme Court. Now there's an interesting new move, and I'm going to mention it right now. Pursuant to Chapter 10, or Title 10 rather, of the Idaho Code, Chapter 1201 and 1202, there is a move, a technical move that we can make in taking by statute this petition for our redress of grievance on constitutional issues before the district court. Now we're going to experiment with that, and we're going to start right away. Now, wherever you are, and by the way, we asked a judge, or the judge rather, just approached a fellow and said, why don't you do this? You see, here's a judge that's saying, hey, you guys keep coming into our courts all the time, and you cost us $1,500 every time you do a trial, and then you're always found guilty, and you always appeal, and you always get bogged down in the appeals process, and the prosecutor won't answer your appeal, and so we never get it adjudicated, and it just costs us a lot of money and a lot of harassment for you because the police keep giving you these tickets. So why don't you use Title 10, Chapter 12, and go up to the district court? So we went out to the judges the other day, and we said, well, would you kindly sign a letter to that effect so that when we file the motion that the district court will be more inclined or more interested in taking it on? And they seemed very amenable to that. Yeah, we'll do that. Now, I don't know where you are in your state, and remember that we've been working in this county for about a year and a half. But the reason I bring that up is that after you've done this for a while, and I think that our county, Ada County, has spent somewhere around $100,000 on a number of citizens, probably 50 or so citizens, have taken their cases into into our traffic courts. And this is something to always keep in mind. Now, if you want to be heard, always demand a jury trial, and always go in and argue the case, and always take a full day when you do it, and always cost your county $1,500. Money rules in this game. I told you that when we were up at Lesson 1 or 2, that there were 4 reasons why a good, competent pro se litigant couldn't be defeated in the courtroom, and money is number 1. Let me show you. The judge told one of our friends, one of our fellow citizens here in our county the other day, well, why are you going to plead not guilty to these 3 parking tickets? Why, this is going to cost the county $1,500 and take an entire day, and you're going to be found guilty. And the fellow used our standard stock lines. I guess he's heard them from me or someone, and he said, well, if you're real concerned about the cost to the county, why don't you dismiss it? Well, I can't do that because I'm the judge. Well, why do you look at me and condemn me then? Why don't you condemn the prosecutor for bringing these charges against the citizen? Why don't you condemn the prosecutor for squandering and wasting the taxpayers' money? I'm not guilty of any crime, and you come to me and ask me to plead guilty to something I didn't do and I'm not guilty of in order to save the taxpayers' money? I think the taxpayers should be informed as to how their money is being squandered by their public servants, who are in reality public tyrants. Well, the judge didn't have a comeback for that one, and so I guess the trial will go on, and the pro se will lose to the jury, because the jury, remember, is composed of licensed drivers, and they all put money in the parking meters, and so their attitude is, well, then, I'm a slave, and you have to be a slave also. Remember the Toby formula? The slaves pretty much want to stay slaves. And the free men want to be free, but they tend to be judged by their fellow slaves and not by their fellow free men. Now, to recapitulate on this, notice that we've talked about these simple citations, and if you've had them, I'll just comment here in closing on the citation aspect of it. This thing is not a complaint, and in the state of Idaho, we always file a motion with the court demanding that these tickets be subjugated to a complaint. We want a formal complaint, and we want an affidavit in support of the complaint. That puts them to a little more work, and it costs them a little more money, and it protects your rights. And what you're doing is that you're denying the jurisdiction of the court, and besides that, there's a rule that grants you that right. And so if you've got the right, exercise the right. And in addition, runs the cost of the case up. Never, under any circumstance, do anything that will cut costs on the case. It's not to your benefit to do that. The reason that they're willing to listen to us now more intently. Now remember, in the early days, they used to make fun of us and ridicule us and throw us in jail and beat us unconscious. Now they don't do that anymore, and they're at least now willing to listen to us. You too, wherever you are in your county, are going to, be subjected to, and you're going to experience some hellacious intimidation. But what it's done here, the more you try to intimidate a free man here in Idaho, the more he gets his back up, and they'd actually be better off, and I've said this for years, if they just leave us alone and ignore us, we'd dry up and blow away in a week. I doubt seriously that we could even function unless our government would oppose us. But it seems like these fools have it in their minds that what they've got to do is to beat us down. That's the Hitlerian type of mentality. What we'll do is force and beat and browbeat. And, boy, when you do that, people are being oppressed enough as it is. Now you throw the guy in jail over the weekend, he really comes out mad. And that's what they are doing and have been doing here. And the word on the street as of the past week, it's as March 1983, is that the lower court judges have decided that we're making such inroads and that we're teaching so many new people how to go in the courts that they're afraid we're going to bog the whole system down. And that's right. You see, their money-grubbing system is what we're attempting to put an end to. This thing of stealing people's automobiles and fining people $40 for pretended crimes and railroading them through and stealing their property from them under the color of law is what we want to put an end to. I had a judge tell me the other day when we were talking to him in chambers that, well, what would happen? How would we function if all these people took their license plates off their cars and turned their licenses in? Why, we'd have nothing but anarchy and chaos. And I said, poppycock. You haven't got one person in 1,000 that wants to be free, let alone even knows how to be free. All you have to do is let those blacks ride the front of the bus that want to ride the front of the bus, and 99% of them will ride the back of the bus, and nobody will care, and nobody will be hurt, and everybody will be happy. But boy, when you start grabbing those blacks and throwing them in jail and oppressing them, all of a sudden then you get a real reaction, and that's what they're doing. And this has been done over and over again in history. I don't know, nobody, I guess, ever seems to learn that when you try to oppress people and get their money, they will sit still for the oppression for a long period of time. But then when they start to squeal that government agents ought to back off and let them get their breath again and then put the screws to them again, they could do that forever. But they don't ever seem to do that. They just put the screws to them until finally they have a real rebellion or a revolt on their hands, like the blacks in the South. And then you have some real traumatic changes. Now all of a sudden you got blacks eating at the table with you, Boy, that was really obnoxious to those people in the South when it was going on. Now, I'm going to spend the rest of the time running through this file folder here because I want to familiarize you with this file folder because, let me tell you, as you progress along now, we're talking about heavier and heavier material. And up through this lesson, remember the first 6 lessons you did, that's the background, and that tells you who and what you are and why you're a slave and how you got that way. And the next 6 lessons are designed to introduce you to the courtroom and some motions and the procedures. And then we're going to get into some real heavy, detailed type courtroom strategy and procedure, how to, when you're talking to a juror, how to ask the juror the question that will cause the prejudice that'll create the dismissal for cause. I mean, things like that, and we're going to really get detailed. Now, the difference between then a citation and a complaint is that the complaint is a formal document that comes from the public prosecutor, the attorney general, or the prosecuting attorney. And you should always demand a complaint in place of that citation. Now, once you have a complaint, it can be served, or it can be administered, I should say, either by warrant or by summons. If you have a lawful summons from your court, just make your appearance and do it specially and not generally. Take a look at the arraignment and plea in here, and it'll give you an idea. When we're talking about an arraignment and plea, you walk into the court, and if you can't speak, just read right off the arraignment and plea. We've even had people walk in and say, well, Judge, I don't talk too good, and here's my arraignment and plea, and everything I need to say is right here in writing. All right, now, when you have a warrant, remember in Idaho, that warrant has to be signed by a judge and then returned after the arrest. And that warrant is a part of due process. Always demand the warrant that went with the complaint and or the affidavit in support of the complaint. Now, we talked about subpoenas, both civil and criminal, so when you want to bring witnesses into the court, you're going to need the subpoena power to do that. And then the parking ticket, that's the Mickey Mouse tickets that all of us get. We just pretty much ignore those. They're not even prosecuting those here in Ada County. The key thing to keep in mind that there is no witness to the event. And when you're talking about a criminal action, you have to have a witness that can say, yeah, I saw him park the car there and I saw him get out and walk away. Well, lacking that, you don't have any cause of action at bar. And you should challenge it on that basis. But here again, I don't care whether it's a felony or parking ticket. Take a look at that file folder and you're going to look through it yourself. I treat parking tickets just like I do crimes of any nature and grade. And I fight and I argue each and every one of them with the same intensity. And then finally we're talking about due process of law under both the 5th and the 14th Amendments, and you cannot have due process of law unless you have all of the paperwork in order. And if they don't do the paperwork, you should complain, you should object, you should file motions for dismissal for reversible error and extreme prejudice anytime that there is a major constitutional issue and every time that major constitutional issue affects some rights. Now, this isn't in any particular order, but I want to show you what you're looking at in this case. This is the entire case up from the time of the arrest up through the time that it was dismissed. So I think the arrest took place about April 9th, 1982, and the dismissal was something on the order of, August 30th, something on that order at a motion hearing. Now, first thing I want you to take a look at is a thing here called the transcript of a preliminary hearing. This transcript, dated June 28th, 1982, is it's on regular size paper, and it's, let's see, how many pages have we got here? Are they numbered? We got 95 pages here. This 95 pages covered about 2 hours of a preliminary hearing in which I was just doing everything in my power to get the charges reduced from felonies to misdemeanors and the misdemeanor dismissed. And I think I did get the misdemeanor dismissed, but the judge bound me over to the district court anyway. Now, originally they filed a complaint and they said I did these things and charged me with a felony. Then later they brought the information in. Now notice, when I went to the preliminary hearing, which is on page 1 at about the middle of the page, you'll notice that I brought up some preliminary matters. So what I'm telling the court is that I want to tell you what my rights are, and I want to bring up these preliminary matters prior to moving forward. As you read through this transcript, 95 pages, the state paid $2 a page, so this preliminary hearing cost our government a couple $100, which was my right to have this thing. And after all, if my government thinks this is important enough to throw me in jail for 14 years, which is the penalty for this felony. And by the way, I ought to bring up right now that somehow or another a jail suit was torn into 11 pieces, and it was underneath my bunk. So don't be surprised if your government agents try to frame you in jail. Always be alert to the frame-up. It's relatively easy to win, and it's not difficult to beat because, after all, they're not going to grant you your constitutional rights. And I don't believe that there ever was a time when I was in jeopardy, and I don't ever believe there was a time when the issue was tearing up the jail suit. The issue was counsel and prosecuting attorneys and grand juries. The issue was whether or not we're going to get a fair trial or whether we're going to be prosecuted by one of the king's agents. But I want you to notice that as you're reading through this transcript, follow through and watch the way I handled that. And I don't claim to be good, and I don't claim to be a professional. I'm just a citizen like you and everyone else. I'm just saying that we have developed a program here and a methodology whereby when we demand our rights and we go into court, we have good results and we win every time. And I want you to follow through with that. Improve upon my mistakes, but try to avoid this temptation that you're going to have to experiment by saying, well, I could never do that and I wouldn't say that. I had a lady in here not long ago and she was being sued for something. And we brought up the subject matter to her of dirty hands, because in equity, one of the maxims of equity is, of course, and check in Bouvier's Law Dictionary and see if whether I quoted this right, but one of the maxims of equity is you cannot come into court with dirty hands. And this lady, for some reason, just couldn't use the words dirty hands, and we showed her that that was a maxim that came out of Bouvier's Law Dictionary, and it's a common term like sliding down the slippery slope, and for some reason she just can't handle that. Well, I'm not going to tell you what to say or how to say it. I'm just saying that it would be in your own best interest, it would seem to me, to follow the proven winning technique first. And I've always said this in the business world. I don't care if you improve upon what I do, but first of all, I always demanded that my subordinates do what I did, because I may have, there's 4 ways to do things. There's the first best way, second best way, the third best way, and the fourth best way. You see, all 4 ways of doing something gets the task accomplished. It's just that the first best way is the fastest and cheapest, and the fourth best way is the slowest and most expensive, and has the least profit. Well, let's assume then that what I'm doing here in this transcript is the slowest and most expensive. It got the job done, and I won the case. Now, once you get to the point where you can get the job done and you can win the case, then you can do it faster and cheaper and easier by cutting corners or doing something else. But boy, let me tell you, this paperwork is so crucial and so important, it's absolutely imperative. Failure to do your paperwork will spell defeat. And I mean, it's going to spell defeat where it counts, and that's in the appellate process. Because remember, all this paperwork that you're looking at in this case was never at any time for the benefit of the magistrate. In fact, not very much of this paper was really designed for the district court judge, because we thought that we would go to trial and the jury'd come back guilty. All of this paperwork is designed, and the statements are designed to show that there are rights violations. I'm demanding counsel. I'm demanding a public prosecutor. I'm demanding these basic rights, and I'm that belligerent claimant. And, Your Honor, I want you to know that I'm here live and direct, and I'm in person, and I'm demanding these rights. And then pull out your little green book here, turn over here to page 32 and just tell them, read it right out of here. Those judges a lot of times will choke because they recognize these statements from the Supreme Court themselves when they went to law school. And I'll tell you this much, boy, in the state of Idaho, you bring up the subject of the grand jury and an information in the same sentence, and the judge is just going to come right off of his bench, and he's going to yell and scream and paw the ground and bite the bushes. We just had one in Mountain Home, Idaho, I believe it was yesterday. And Niels came back in here and told me that they went to an arraignment for a felony, and the judge just come unglued when we brought up that subject matter. I'll tell you that judge is wearing his feelings out here on the end of his coat sleeve, and every time you rub it, it chafes. Now, I don't know why a judge would necessarily get so uptight and upset because a citizen, just the average Joe Dokes that works in the sawmill or does whatever he's doing in life, comes into the court and demands his rights. But I suspect it's because it is such a threat to their power base, and that hasn't occurred in probably the last 50 years. You see, they have a system that the judges, they actually have a judge that rotates around, and he looks at all these cases that comes through the prosecuting attorney's office, and he decides which cases will be prosecuted and which won't be prosecuted. And to that I say poppycock. I say that every case has to be brought before a grand jury when it's of an infamous character, and let a jury of the community or jury of the county decide whether or not we want to prosecute that. If we were to bring these cases before a jury, that is a grand jury, and I'm being charged with the theft of 2 traffic tickets out of the traffic court that they're now calling court documents, I'm facing 40 years in prison or a $20,000 fine. And, just telling you that you've got 2 of these traffic tickets missing. I don't know if they lost them or what. For some reason they're missing out there, or maybe it's just a plain frame-up. I don't know. Maybe they're just mad at me and they just want to put me in prison and want to punish me. But I think what their problem is, they want to get a felony conviction to prevent me from running for office. So for all of you out there that think I'm going to run for office, I want to put your minds at ease. I'm not running for office. I know I'm not a politician, and I know that I don't have the mentality for it. I used to think I was a prophet, and I remember about 1968 I made some prophecies, and I thought that, well, let's see, the first prophecy was that the temple would be built in Jerusalem starting in 1968, and I thought that the tribulation would begin about 1972, and then I thought the second coming of Christ would occur about 1975. And then I got to reading, I think it was around Deuteronomy 8, and it said something about if a prophet come in my name and he makes these prophecies and they come not to pass, then you'll know that I haven't sent him. Okay, I just want you to know that God didn't send me because none of those prophecies came to pass. And I found out right away that I'm not a prophet. Figured that right out. So I don't know what I am, I just know what I am not. And another thing that I know that I am not is a politician. So I don't think I want any office, and I don't think I'd take office. I don't think I have the mentality, and I don't think that I'm that corrupt. In fact, I'm, at this moment in time, I believe I have the moral character and the honesty and the integrity to tell you plainly that I would not serve in a public office, because I don't think that those politicians who serve in a public office have the kind of character that I have. And I'm not saying that I've got any character at all. You know, I'm just telling you in plain language that my character, whatever it is 3 or 4 notches above any politician I've ever met. So if any of you are prosecutors out there and you're real concerned about George Gordon running for office and straightening the world out, you can forget about that. I want you to notice over here on page 5, you'll notice that there's a Ms. Carnahan in here, and there's a thing called direct examination, and then later on there's a thing called cross-examination. And you'll notice that during cross-examination, Ms. Carnahan would object. Notice these objections in here, and notice the language that the judge and the prosecutor use. And try to pick up on that type of language and the phrases that are used in here. It isn't crucial to you that you learn that, but your acceptability in the courtroom and your professional ability when you get into the courtroom is going to be recognized by the judge and by your adversaries and opponents by the words that proceed out of your mouth. I think there's some kind of an old-timey proverb that runs something like that. It's something like, out of the abundance of the heart the mouth speaks. So out of the abundance of what you have in your mind is what's going to come out. And so here's an opportunity for you to actually look at a preliminary hearing in which I had an opportunity to have this case thrown out, and I worked hard, and I tried to win. But the judge bound me over. Take a look at this, read it, don't have to memorize it because we're not going to have a test, but read it, and then see if you can find why the judge bound me over. Was it prejudice? No, I don't think so. Was it that he had to because of pressure of the judicial system? Well, I think that's probably more it. I don't think they had a case. But anyway, there's an official transcript of a preliminary hearing, and you've got one live and direct. Now, looking at the balance of this file folder, you'll notice, would you zero in on this one? This happens to be number 33. Notice up here in the corner that there's a number. Now, if I haven't mentioned this before, when you're filing paper, there's your number 33 that you put on your paper, and then, of course, you put number 33 on the judge's copy, didn't you? But when you gave that to the prosecutor, you didn't put number 33 on there, did you? You see how that works? I don't let my adversaries in on the same numbering system that I have. And you're going to notice, and I'm just going to start running through here. They're not in any particular order as I go through, but here's a jurisdiction brief. Now remember, jurisdiction is a crucial issue in any case that you do. You're going to challenge the jurisdiction of the court because, remember, and keep this in mind, jurisdiction also embodies this thing of the ability of the court to effect a remedy. I was in court the other day, and went to a sentencing hearing. The jury came in, found me guilty, and we went to a sentencing hearing, and I laid the money issue out. Now, in the state of Idaho, our state statutes, and I think this is 2822-101. Check that out. Idaho Code 2822-101. And take a look at the definition of the dollar. You see, the money of account of the state of Idaho is measured in dollars. And then when you take a look at Article 1, Section 10 of the Federal Constitution, and you take a look at our money briefs and some of the other briefs that we have and motions, and the Coinage Act of 1792, and etc., you'll find out that the dollar is 371 1/4 grains of silver, and it weighs 412 1/2 grains total. Well, when I brought that up to the judge, this was very interesting. This judge said, well, because of your money issue, Mr. Gordon, I'm going to suspend the fine. Now, we've been here 1.5 years, and we've been preaching the money issue for a long time, I think for about 1.5 years, and they're finally beginning to say, and there was another judge the other day that said, you know, you people probably have something there. So maybe in 1 year from now, we'll really turn the apple cart upside down or right side up. Now, I'm going to open up this file folder. Would you zero in on this? Let's take a look. Now, notice that this is the nomenclature, and if you'll notice right there, what you're looking at is, it says felony on jail clothes. There's your title. And then it says number 1, complaint and case number, 25C-1166. And it says a list of charges against the jailers and statute on charges and the motion for discovery. What you're looking at there is my list of every motion, and I filed a total of 34 papers in this case. Between my opponent and myself, we had 34 pieces of documents. All right, as you go through these 34 pieces of documents, you'll see the order in which they were filed, and they're roughly filed. You know, the first thing that happens is you get a complaint, don't you? And then you go on through, and then finally at the end here, you've got a notice and demand for a public trial and or hearing. And without making a big to-do, you can read these for yourself. Now remember, when we get into the motions, and I'm going to talk at long length on how to write motions and teach you how to read statutes and plead the complaint, and how to challenge the statute and look for the key words that are used in statutes there to cause to make loopholes in the law. You know, the people that write these laws are lawyers, and they don't want to be entrapped by the laws that they make, so they put loopholes in there. As soon as you learn how to cover those loopholes and how to worm out of it, then you'll be right uptown with the rest of the lawyers. All right, now let's just take a look at number 33. I happened to get this, and it was called status to contract. Remember, in lesson 1, I believe it was, we went through this thing called status to contract, and I want to pass on to you a little trick here that you're going to do at an arraignment. If you have this paper, you can serve it at arraignment if you've got it ready. If you don't have it ready, don't worry about it. You can make motions all you want, or notices in demand, or I demand that the court take judicial notice that I demand counsel of my choice, and that I demand a public prosecutor, and that I demand a grand jury indictment, and that I absolutely object to and reject this information, and I do not give you permission to prosecute me by any information. So you do that orally. You just do that right off the top of your head. Sometimes you'll be in jail and you'll be brought to an arraignment or a bail-setting hearing, and you make those same demands. Then you file the paper in support of those oral demands. Now you'll notice that this says status to contract. Remember, you're telling the court then that you're not a person who is required under these statutes or titles to the specific performance that's being required of you by the state statutes. That's in effect what you're saying in this particular jurisdiction brief, memorandum of law in support of jurisdiction. So you're challenging their jurisdiction, and there's your status argument. You'll notice here number 5. Flip along through here and find number 5. It's called a motion for a subpoena ducis tecum. All right, now, the subpoena ducis tecum is a motion to bring forth the physical property, that is the rags, in this case the jail suit that was torn up, so that I could show it to the persons who were going to testify to it, and they could put it in their hands and they could look at it, and we could testify about it. And comes now the defendant in the instant case, claiming all of his rights under the common law and waiving none of them at any time, appearing by motion, not granting jurisdiction to this court as the issue of jurisdiction is in question, to wit. So you see, there's your opening statement. Almost every motion you write, almost every appearance I make. I don't think I've ever forgotten. If I did, it was an accident. I always challenge the jurisdiction, and I always demand my rights. To order the government, so I'm asking the court then to order the government to bring forward at the probable cause hearing any and all rags alleged in the complaint to have been destroyed by this defendant on or about April 9, 1982. These rags are necessary and imperative to the defense in the instant case dated April 21, 1982. Now keep in mind, in the state of Idaho, you have to be brought to this preliminary hearing within 21 days if you have been released from jail, and within 14 days if you're still in jail. On the 15th day, you've got another motion, and that is, I move to dismiss for failure to bring the defendant forward timely under Rule 5.2 or 5.1, whichever it is on preliminary hearings, or for failure to bring the defendant forward timely. Now, this last felony, the judge involved didn't bring me forward for about 27 days before we went to the preliminary hearing. Now, that being the case, then, I'm going to file a motion in that court for dismissal for failure to prosecute timely. If I don't win in the district court, or if this Mickey Mouse case, and I'm going to call it just that, a Mickey Mouse case, isn't dismissed, I think most any judge, can see that the loss of 2 traffic tickets is something less than a major crime. Should dismiss this. But I'm going to raise the issue, and I'm going to challenge it. And you've got to be, and I'm going to be, in this, a belligerent claimant in person. Anyway, this will give you an idea here that the words necessary and imperative are words that I picked up from the Supreme Court. And anything I ask for or demand, it's necessary and imperative. And then the judge will say, well, you could get by without one of these. Now, couldn't you, Mr. Gordon? Absolutely not, Your Honor. I can't conceive of any way that I could continue or go forward without the physical evidence in the hands of Officer Honey as we ask him questions concerning how he found them, where he found them, and the physical condition of the rags themselves. Don't ever let them shake you off of that. And the judge probably, won't let you have them. But at least when the appeals court looks at it, they're going to say, hey, this guy really lost his rights involved in this case because he said they were necessary and imperative. And the judge didn't let him have the rags in the courtroom, and he bound him over, and then later on he went on to be convicted, and now he's in the penitentiary. You see how important that one piece of paper could be to me if in the event things had gone wrong and the jury came back guilty and the judge just said, go to jail, do not pass go, do not collect $200. The fact that those rags were necessary and imperative, my contention is that had I had those, I could have shown the lower court judge at the preliminary hearing that there was no cause to bind me over. And without that cause to bind me over, I would have had my case dismissed and I'd be a free man today. You see how that one piece of paper can make the difference between victory or defeat. Well, there's a lot of these motions in here, and I'm going to wrap this particular lesson up right on this note. You've got this file folder. Here you have a case, and you may be the only time you've ever seen a case that's actually won. I've got a lot of them. If you want to buy some more, I can probably sell you 10. I think I've got about 10 file folders like this of cases that have been won. They're basically misdemeanors. And we'll be happy to put them together and give you a price if you want to see them. But I think this one here will be more than adequate for you, and I think that you can copy this. Remember that we're not concerned about copyright laws. This paper that's in here is mine, and I own it, and I'm giving you permission to go ahead and copy it. It would be very advantageous to a number of people, though, if you could keep it in its entirety, from beginning to end. Item 1 through item 34 should be in here just the way it is. So there you have the service of process and the identification of the various and sundry type paper that you're going to be dealing with, and a complete case with a victory. And believe me, if I can win, so can you.